Hi, I'm Peter Dyson. I practice law in Delray Beach, Florida. In the newspapers or on TV or on the internet, you might read a lot about motions to dismiss and motions for summary judgment. Today, I want to talk to you about some of the key differences and how it affects a case. Motions to dismiss have two different tracks. The first track, where most motions to dismisses are filed, is something you don't have to worry about. That first track, you have leave to amend, what means that any deficiencies that they claim you have in your lawsuit, you can clean up and submit a new lawsuit and continue on with your case. That is by far the most common motion to dismiss. The second track, which is something you do have to worry about, will dismiss your claim forever. And that is rare because it might address something such as your past statute of limitations. In other words, you didn't meet the deadline to file the lawsuit. That there's nothing your attorney can do about it, and the claim will be dismissed forever. A summary judgment only has one track. The other side is trying to throw out your case and have the judge decide that they're right. Now, a judge cannot grant that motion if discovery isn't done yet. In other words, you're allowed to have an opportunity to conduct depositions. You're allowed to have an opportunity to get written discovery in order to fight that summary judgment. Also, a summary judgment will not be granted, and the term they use is a disputed material fact. Let me talk about what that disputed material fact is and how it would work in a summary judgment motion. A court will not throw out your case if there are disputed material facts. So let's talk about an auto crash. Let's say the crash happened at an intersection where there's a stoplight. If you say you had a green light and the other side said you had a red light, that is a disputed material fact. A judge cannot decide that. Instead, that would go to trial and be decided by a jury. But what if you agree? What if you say, yeah, I had a red light and I went forward anyways? And the other side agrees. He had a red light. Well, then summary judgment will be granted against you and the judge will decide your claim that you were in the wrong and you were negligent for running that red light. That's just one example. There's so much variety in cases that we can't talk about every material fact that could be in dispute, and discovery changes everything. But I want to give you a brief understanding of what a material fact is and why a judge can't decide if two people say the opposite things. I know I threw a lot of information at you right now, so let me give a quick recap. A motion to dismiss has two tracks. The first, you just want to amend the complaint and continue going forward. That happens before even discovery takes place. There are some situations where a case will be dismissed outright, but those times are rare. A summary judgment happens after discovery has taken place, and one of the parties is asking the judge to decide. They're asking the judge, there's no dispute, we should win, and no reasonable jury can find for the other side. A summary judgment will end your case. If you're involved in litigation or have any questions, talk to us right away.